criteria are entitled to be a socially and educationally backward class, which is why, sir, this honorable court very rightly recommended that transgenders be included as an OBC community. Transgenders. The National Commission of Backward Classes has recommended that orphans be included in the list of OBCs. So this category, created by the founding fathers of our Constitution, has yielded the desired result. It has become the main category uniting the common people of this country across religion and across caste, across region, across geography, as backward classes, fighting for greater representation and a greater share of voice in this country. And as I mentioned last time, sir, every Varna is represented, every religion is represented, every Muslim in Kerala belongs to the backward classes because they really suffer from deprivation. So the first point I want to make very simply, sir, is to rebut this idea that this reservation for communities that fulfill these criteria is being repeatedly vilified as casteist reservation. What is the basis, sir? A caste is entitled to be a class, but casteist mindsets see a class only as a caste because they cannot see anything else, sir, other than a caste when they look. So therefore, I think we must recognize the value of creating a uniting category that cuts across various kinds of deprivation, and we must strengthen it. Now, is that being abused? Yes. What is not abused? And that's why the National Commission for Backward Classes rejected that JAT should be made backward classes. And the government, for political reasons, then government went ahead and gave them OBC category. So these mechanisms are working, sir. And I'm the first to say that these criteria must be strictly applied for the objective of giving voice and representation to people who are living in this condition. And they must be reviewed, monitored, and people who are not in these conditions, which frankly bring tears to my eyes, sir, when I read these conditions. We are talking of actual people, that they should have voice and a share. Otherwise, what is the purpose of our having freedom and democracy, sir? But it should be monitored, and it is not. But we should not throw the baby out with the bathwater, sir. That is my first point. Second, very briefly, sir, is this relationship between weakness and backwardness. I want to rebut the idea, sir, that weakness and backwardness are totally opposed to each other. When I saw the three-circle formula that Honorable Justice Butt put forward, what appealed to me was there was a continuum running across that circle, and that was weakness. Weakness. The word weakness comes from the Proto-German word Weiku, W-A-I-K-U. It means soft. It will yield. No capacity to resist. So if you take Justice Butt's circle, as he said, at the center you have the greatest weakness of SC and ST. Then you radiate out and the weakness is less. The capacity to resist improves. And at the outer end, I would say are residual. There's massive human suffering in these groups, and to call them homogeneous because they're assumed to be caste does not do justice to that category, sir. So I think we must understand that weakness is a quality, sir. It's a quality of yielding, being soft. Backwardness is a rank. Are you towards the back or are you towards the front? Weakness produces that rank, but you can't, they're not intended to be opposed to each other. You cannot use backwardness to fight weakness or weakness to fight backwardness because they're two categories. And I saw in these three circles, sir, a rank and a recognition of weakness as I saw it myself. And I thought that was quite very helpful. Lastly, sir, my rebuttal point is, please don't divide the joint family, constitutional joint family of social, economic, and political, sir. They go together. The rest of the world has just begun to realize that what is social is economic, what is economic is political, what is political is social and economic. They're all different sides of a complex human condition. And so we have moved away, sir, from, in the last 70 years, from measuring poverty simply by looking at consumption and the right to buy food, to multidimensional poverty indicators, where we are looking at various aspects. And we find, sir, that poverty is defined as a multidimensional problem. No less than the IMF said, sir, that it's a multinational and multidimensional problem that goes beyond economics to include, among other things, social, political, and cultural issues. This is a recognition that we had in 1950s in our constitution, always speaking of justice, social, economic, and political. And to achieve justice, social, and political, economic, you cannot just look at economic criteria. So separate from Indira Sawhney, sir. Indira Sawhney expressed the right sentiment. Now, if today you were to offer me the proposition that reservation should be on social criteria alone, I would be the first to oppose it, sir. I will say, don't ignore the economic criteria. Don't ignore the political criteria. If you say reservation should be only on political criteria, I will be the first to oppose it. I'm not against economic criteria, but I'm against single point criteria to determine human suffering and human backwardness. Poverty remains an extremely complex morbidity to recognize. But if we have made any progress, it is to realize the complexity, not to reduce it to 8 acres of land or X amount in the bank. So we've left that behind, and I think India will be shamed in the rest of the world if we still show that that is our approach to understanding human suffering, sir. So these are my 3 rebuttals, sir, very quickly. I'm aware of the time. Now I want to move to 3 basic structure violations, sir. We've all focused, and my learned colleagues who are far more able than me and far more knowledgeable than me have very deeply pointed out many, many basic structures, although the respondent side has tried to narrow us to only two issues of whether or not economic criteria can be is valid under the Constitution, whether there's 50% reservation. But actually, number of submissions have been made on basic structure. But many of these submissions have focused on the exclusion. I want to focus on the inclusion, sir. My real problem is with the inclusion, not with the exclusion. And what is my problem with the inclusion, sir? My problem with the inclusion is that for the first time in our history, being a member of a forward class, socially and educationally forward class, has been made a prerequisite for getting government assistance. If I'm a member of a born as a member of a socially educationally backward class, sir, how do I become a member of a socially and educationally forward class? Never before, sir, in the history of this country, has there been a requirement that to get government assistance, you have to be a member of a socially and educationally forward class. You have to be socially and educationally forward. This is why I think, until recently, the idea was to tackle financial weaknesses. Yes, there are genuine cases of financial weaknesses. I myself know one person, sir, who's a member of the royal family of a state, and he was telling me how he grew up in utter poverty, had to eat roots when he was a child. And I told him, I said, yes, you had to do that, and you should never have had to do that. Your suffering is no less or no different than any other child in this country. But you must remember that no door was closed to you by society. No door was closed to you. I know someone else who was very poor from a priestly family, because the father and the grandfather decided that they want to serve the temple and be priests and live in that condition. But when the children decided, no, we will study, sir, every door opened for them, sir. Every door opened for them. In school, in college, outside the country, in the best jobs in the country, and my friends, both of them ended up in top positions in the country. So our problem is with doors being closed by society on us. And that is a problem that can be solved only by forcing those doors to open through a reservation, a set-aside such as reservation. Now let me turn to, so my first problem is that this requirement violates the basic structure. And I will come to that in the methodology in more detail, but that's the first. I'm only submitting that 3 things violate the basic structure. One is this prerequisite that you must belong to a forward class to get EWS is a violation of the basic structure, number 1. Number 2, sir, there is a requirement that, sorry, sir, I'll just take 1 second. Yes, sir. The second difficulty with the violation of the basic structure is that is about the way 103 amendment treats reservations. Now, I believe reservation is a very dangerous instrument, sir. It's a very dangerous instrument. Because it necessarily involves displacement and discrimination. You're pushing someone out to get a chair, which is why we are before you, sir, because the question is that being done fairly and justly or not? Now, because reservation is a very dangerous instrument, Dr. Ambedkar himself in the Constituent Assembly said, don't apply it to more than 50%. Not because he wanted that to be a rigid criterion to be used to destroy the social and educationally backward classes and the SC, ST, as some of my colleagues may wish to do. But because he realized the danger of reservations, and he wanted more than anything else that every Indian should have equal opportunity. That's what the struggle of the movement always was. So it's a dangerous instrument. So therefore, they anchored that those reservation, put chains on it, so that it will not run out of control. The chain was that you shall be used only for representation, and you shall be used only for representation by backward, for those who are being discriminated against. That instrument, you can do anything else, you can help people in any other way, but this dangerous fellow, don't use him for anything else except to open the doors that society closed on you. You use him as a lever to open those doors and nothing else. Now, what 103 does is, sir, it destroys those harnesses on reservation. It says to uplift someone. It doesn't matter whether he has suffered from discrimination or not, but to uplift someone, you can use reservation. It is reservation unbound. If this amendment is approved, in short order, sir, there will be thousands and thousands of programs in this country to give exclusive assistance to various groups of people through reservation. Reservation will be unbound and let loose on this country. So instead of tightening that and making sure that it does not apply except where the truly deserving need representation, we are doing the opposite by universalizing and compartmentalizing reservation. I agree, sir, with you that compartmentalization already exists. It's a problem, sir. Let's not make it worse. When I heard the arguments about compartmentalization, ma'am, my mind went back to 1896. I was never there, but went back to the Supreme Court of the United States in 1896. Bless you. Where they considered a case where a law was enacted by the state of Louisiana that railway compartments, it's ironical that the other side used the word compartment, railway compartments will be reserved by race. One compartment for whites, one compartment for blacks. And if you a black entered a white compartment, you would be fined and prosecuted. And so some civil rights activists decided to test that law. A man who was partly white, partly black entered the compartment. He was caught, he was prosecuted. He appealed the case. The case went to the United States Supreme Court in a case called Plessy versus Ferguson, 1896. And in that case, the state argued that what I am giving is compartments, separate but equal. Separate but equal was the defense of the state. Everyone, no, I'm not taking your share. You won't take my share. What is your complaint? You're getting your own compartment of the same quality. So the state argued separate but equal. And it was upheld by the US Supreme Court in what has today become one of two most disgraced judgments of that great court. It took until 1954, 60 years and 3 or 4 generations before it was reversed in Board versus Brown of Education. So I was reminded of the arguments that were made in Plessy and Ferguson when we heard an argument from our union that we want separate compartments and no one should complain, just be in separate compartments. So this is a violation of the basic structure idea of unity and integrity and harmony and fraternity of this nation. Fundamental violations. if an imprimatur of the Constitution of the Supreme Court is put on this argument, which has now been openly placed before you, sir. You cannot but take judicial notice of this. The Attorney General of the country has placed before the Supreme Court of the country, we want separate but equal. And it took 60 years for the United States to realize that separate but equal is nothing but separate and unequal. That's what it is in reality. And therefore, sir, compartmentalization and unleashing of reservation becomes a free agent virus running through society, compartmentalizing everyone. What is the legacy that you will leave us, sir? So these are my limited points, sir. I have about 7 minutes left on the basic structure violations. I move to the last part, sir, methodology. And on methodology, sir, I turn to Justice Kapadia's judgment, sir. Wonderful judgment, as all of you know him, a judge of great clarity and great wisdom. Sir, if you turn to para 22 of the judgment in M. Nagaraj, so I don't have the right, I rely on Indian Qanun and all that, sir. So I don't have the right numbers, but it's para 22.
122.
Sorry? It's page 242. Yes. Yes. I'll just read the quotation, sir. The question, because my time is limited, I have only 5 more minutes, sir. The question which arises before us is regarding the nature of the standards of judicial review required to be applied in judging the validity of the constitutional amendments in the context of the doctrine of basic structure. So this is exactly on point, sir. Justice Kapadia is giving us a methodology on how to decide the validity of the constitutional amendment in the context of the doctrine of basic structure. Sir, if I would like to go through, but I may need another 4 or 5 minutes, sir, if you permit me, sir. So, sir, para 23 says the recognition of a basic structure. It's a brilliant analysis, sir. Recognition of a basic structure in the context of amendment provides an insight that there are, beyond the words of particular provisions, systematic principles underlying and connecting the provisions of the Constitution. So what is clashing with the basic structure, sir, are the principles underlying the provisions, not the provisions themselves, is what Justice Kapadia is telling us. These principles give coherence to the Constitution and make it an organic whole. These principles are part of constitutional law, even if they are not expressly stated in form of rules. Now, this is a very important and significant limitation to the idea of basic structure, sir. Justice Kapadia is saying that if you want a principle underlying a provision to be part of the basic structure, it has already got to be a part of constitutional law, recognized by courts and binding on the legislature. So that prevents anyone from coming in and putting any random principle as a part of the basic structure by just putting it into the Constitution. So you have to go through a process where there is a law, there are principles that are established by courts, accepted and are binding on the legislature. Then you say, okay, that is the principle by which I will determine the nature of the provisions. He says the provision acquires its characteristic as a feature from this underlying principle, sir. So it's like saying there's a car. A feature in the car is it has steering wheels and brakes, and it has a radio. These are all features of the car. But some features are essential, like steering wheel and brake, but the radio is not essential. So Justice Kapadia says, I won't read the whole thing, sir. Justice Kapadia says, you look at the provision, you identify the underlying principle, and then from that underlying principle, the provision gets its features. And then you see where that underlying principle fits in the larger scheme of the Constitution, its goal and its scheme, its objects and its scheme. And then see whether it is a radio or a steering in relation to that whole scheme. If it is essential, then you say it is part of the basic structure. That underlying principle is part of the basic structure. And as I said, sir, that gives us the safeguard, a great safeguard, that unless a principle first becomes part of constitutional law, it cannot even be a non-essential feature of the Constitution. It cannot even be a non-essential feature of the Constitution. In my academic work, sir, I have emphasized this, and I've regretted that this has not been developed more to prevent, this is a safeguard to prevent random principles coming in. Now, sir, I will not read for lack of time, I will not read the rest of the passages, but I'm looking at para 22, para 23, para 25, para 28, and para 37. In 28, Justice Kapadia refers to the working test evolved by Chandrachud J in the election case, in which the learned judge has rightly enunciated with respect that for determining whether a particular feature of the Constitution is a part of its basic structure, one has perforce to examine in each individual case the place of the particular feature in the scheme of the Constitution, its object and purpose, and the consequences of its denial on the integrity of the Constitution as a fundamental instrument of the country's governance. But I think Justice Kapadia's unique contribution is to qualify that the principle must be a part of constitutional law already and must be binding on the legislature. Sir, now finally, sir, in the last part, let us apply, sir, to apply this principle very quickly, so there's no time, to 15.6 or 16.6. What is the underlying principle of 15.6 and 16.6, sir? The underlying principle is that those who are poor and are socially and educationally forward and therefore deprived of reservation must get reservation. This is the underlying principle. Now, this underlying principle is not an established principle in constitutional law. It is not binding on the legislature. And it is in violent conflict with principles of equality, with the features of the Constitution that already exist to advance its objectives, which have been recognized. I have a list of, don't have time, but I can go through the cases and the specific basic structure principles they establish. Many of them are in Keshwan Bharati. All of you know that more than I do, so I don't wish to take time on that. If you wish, I can. So therefore, sir, if you apply this principle to this test, you easily come to the conclusion that these three provisions, compartmentalism, the forwardness as a precondition, the quality of forwardness as a precondition to get government assistance. So this can be extended as a general principle to all aspects of life, sir, not just restricted to reservation. And the letting loose reservation in this society without any restriction as a benign welfare activity, like a loan mela, right? Just go and give it. These three specific parts of 15.6 and 16.6, I think, very violently oppose or conflict with the basic structure. Last part, sir. Last part. What's the way forward, sir? What's the way forward? Looking at it from the point of view of the court, I think there are two ways forward, sir. Three ways forward. One is to strike it down. The other is to sustain it as it is. But I think there's a third way forward, sir, which does not involve reading down, does not involve severance, and can solve these basic structure conflicts in one stroke, sir. What is that, sir? And that is to take. Now, so this amendment is before you in two versions, sir, now, after these 2 weeks of discussion. It's there in two versions. One version I will call the constitutionalist version, sir, the constitutionalist version. The other version I'll call the forward class version, sir. So the forward class version. Now, I'll take two parts of 15.6, 16.6 and see how it is interpreted in these two versions, sir. You take the phrase economically weaker section. In the forward class version, it is interpreted as socially and educationally forward classes with a creamy layer exclusion, and other than 15.4, 16.4 classes. But in the constitutionalist version, sir, you can read economically weaker sections because of its reference to economic weakness, not financial weakness, and to poverty. The entire justification of the union has been premised on poverty alleviation, sir. And poverty alleviation, as I said earlier, is a much broader context than financial incapacity. You can read it as below poverty line, BPL, with priority to the neediest, irrespective of caste and creed, sir. Send a strong signal to this country, sir, that we've reached a stage where we recognize poverty without respect to caste and creed. This is an opportunity to do that. So the constitutionalist interpretation of this phrase would be BPL with priority to the neediest, irrespective of caste and creed. Now, the more difficult one, the second phrase, other than the classes mentioned in clauses 4 and 5. There, the forward class interpretation is this is like a yellow star that the Nazis gave to Jews. You stick it on you, and wherever you go, you're a Jew. So if you it's a yellow star is a social identity, sir. I would argue the status of OBC and SC/ST are only relevant when you are you're claiming or getting that reservation. If you're not in the room for for claiming benefits, you're a human being, sir. Not a yellow star. You're a human being. If I'm an OBC in one state, there is a particular community, I don't wish to name it, it's scheduled caste in Karnataka, it is OBC in Maharashtra. Now, does that person change, sir? Morph from OBC into SC/ST when he crosses the border? No, he's just a human being. But his entitlements and claims may change. So socially and educationally forward class interpretation are converting class into caste and attaching OBC, SC/ST to all of us like a caste that stays with you. They cannot see us as human beings anymore except as OBC. So we reject that approach, sir, and take a constitutionalist approach. What is that constitutional approach, sir? It is, we see this other than the classes mentioned in clause 4 and 5 as meaning that the eligibility criteria for forming the sections in Articles 15.6 and 16.6 shall be other than the eligibility criteria for forming the classes in Articles 15.4, 15.5 and 16.4. For example, in 16.4, 16.5, you have to be backward. So you cannot use that eligibility criteria in 15.6, 16.6. You can use poverty. You can use poverty. So other than, sorry. Sir, the Constitution is always at the level of criteria, sir, not at the level of identifying human beings. All these are criteria, whether it's EWS or OBC, SC/ST. The Constitution sets out criteria, broad criteria. So why are we reading the Constitution as referring to people and putting a yellow star on them? And why don't we refer to this as criteria? Now the question is, sir, last question is, this will not, as the bench observed.
So what are you saying?
Yes.
That other than means descriptive.
Other than refers to the criteria, not to the people. The criteria shall be other than.
Criteria means it has to be descriptive. See, criteria, we can call it, it's a matter of semantics.
Yes.
Other than means you have 4 socially and educationally backward.
Yes.
Now, other than can mean 2 things. The way we have understood so far is exclusionary.
Yes.
The other way to read, perhaps, is that this is descriptive. In addition to the category in 4, we have this category.
What has been described in 4 and 5.
What is described? In addition to that, we have this. Therefore, in that event, there is no exclusion.
Yes.
Then you can call it a silo, you can call it a separate container, where everybody competes on the basis of poverty.
No, sir, as you can read it in any manner.
You are rendering the entire observation.
that is not a manner that is referring to human beings. Human beings. So, for example, criteria for sports persons is different from criteria for persons with disabilities. So, if you want to get horizontal reservations under either, you can be a scheduled caste woman who's a sports person and is disabled, and you have to deal with 4 sets of criteria. And there is nothing in interlocking reservation that says you cannot have multiple eligibility. So
what Justice Jeevan Reddy said, interlocking
reservations. So what I'm saying, sir, is that we read these as we ensure that there is no overlap. Now, we can attribute, sir, rationality in saying that backward classes and weaker sections are very closely interrelated. They're two sides of the same coin. Therefore, all the more reason to ensure that the eligibility criteria are distinct and with intelligible differentia. So here, for example, no need to put this criteria on what your stigma is or your social status is. You can just concentrate on the deprivation. This MPI, so the multi-dimensional poverty index criteria. You can do that, and yeah. Sorry, sir, sir, forgive me, sir. The last point I want to say, sir, is that, yes, this may mean that the political intention of providing a separate compartment for a particular group may not be achieved, but that is not the concern, sir, of a court. And, that will never be the concern of a court. First, this will not be the first time that a political intent has been frustrated by what Justice K.K. Matthew, I forget the judgment, beautifully once called the need for all constitutional provisions to be in fraternity with each other. So when whatever the political intent may have been, once 16.6 and 15.6 enters the house of the Constitution, it acquires all the characteristics of all its friends in the Constitution, sir. 21, 19, 14, 16. They're all one big friendly family, sir. And they have to live in harmony together. And so this interpretation, where we say that other than means that the criteria shall be distinct, eligibility criteria shall be distinct to avoid an overlap, will allow you, sir, to keep this going without running into the letting reservation run loose, disconnecting reservation from backwardness or poverty, and without
that process. They are disrupting the harmony. This entire process is due in the alternative suggested way forward. It's required to be is taken up only when if we come to a conclusion that these amendments, 103rd amendment, whatever is provided is not otherwise living in harmony with the other provisions of equality wherever they are. If they are otherwise, they could exist in harmony, they could exist.
Of course. But it all depends on what interpretation we give it, sir. These are not provisions which are neutral. So as I said, there are 2 interpretations you can give it. One interpretation will allow them to live in harmony, sir. But another interpretation will not. There's no doubt about it, sir. Thank you so much, sir.
With my lord permission, I am seeking only 30 seconds, my lord. I will point out only 2 things, my lord, 30 seconds, not more than 30.
Your data.
Yes, my lord.
We have seen that data.
Yes, my lord. I want to point out on 2 things, my lord. I want to point out on data. In Jammu Kashmir, 34% OBC people and 2% reservation in Jammu Kashmir on the OBC category. And that matter pending before the alternate bench in item 105, my lord. And state of Madhya Pradesh, SC, ST, OBC people are 89%, and OBC people, admittedly, 52% population in OBC category, and reservation only 14%. And my lord, the ratio is a very important one. I want to read only one paragraph, my lord. This define the.
Get into that issue, that whether the ratio-wise or proportionate representation.
Yes.
What are you hinting at, sir?
So, Milord, these people are not adequately represented in the government sector in anywhere, Milord. That's the reason we want to point out.
According to you, supposing for instance in a given state, scheduled tribes are more than what is the percentage of reservation meant for them. This is what you are hinting?
Milord, I want to point out this, Milord. In a 52% population in Madhya Pradesh, only 13% people are working in the government and PSU, Milord. So this is the actual situation in the ground level, and they are in 20% reservation given.
Sir, what we are focusing on, and again, you would request, sir, how this particular way of looking at the thing would help us in arriving at a conclusion whether this amendment will disturb the basic structure or it disturb the basic features or not. Individual cases or individual layout or spread of the persons or the percentage of persons getting into employment, not getting into employment, maybe because of variety of factors, sir.
Yes, I want to just point out,
Sir.
reservation is the tool to give an adequate representation all corner of the society.
And that what you are now trying to say is that there is inadequate representation for certain sections of the
Yes,
society. Understood. But that is not something that we are called upon to decide. We are called upon to decide completely different dimension of the problem. So we can't by our decision make some kind of, adequate representation for those who are inadequately represented. What we are called upon to decide is what is the information, what is the content, whether it violates basic structure or not. Correct? Your data is not going to help us in that direction.
Only one thing, Milord. If this amendment is upheld, then again, Milord, we are excluded in this amendment. OBC SC is not included. So we are again excluded in 10%
Council
reservation.
have argued well.
I'm sorry.
So please rest.
And I want to just point out, we are already placed the data, Milord, so kindly.
That's all right, sir. You have told us at least 4 times.
I'm sorry, Milord.
Yes, we have understood.
I'll take 20 seconds, Lordship, just to apprise that the criteria of 8 lakh limit is pending before court number 2. So
That's
if
all
in
right.
case Lordship is going to upheld or whichever way, it should not be decided on the 8 lakh limit.
Okay.
We have filed the IA, that is no reason.
Well, in this matter, your lordship made a beginning with advanced written submission.
Mr. Sharan, we
Timeline.
want your again assistance on the point because by the time we have come to the close of this particular matter, we started with say 1 unit, today we are 20 units, correct? We want you to again put that in concise form. If you and Mr. Kanu Agarwal, if you can actually, we can bank on your services, please do that in next 3 or 4 days time.
Because we'll do it in the next 3-4 days. Just one suggestion I had, from the experience we have gained here. Because your lordships may consider advanced timelines and advanced written submission as a part of practice directions for constitution bench matters generally. Because the bar is also learning. Because in this matter, you are learning.
No, it should be not just constitution bench matters, every 3-judge bench matters.
Because the beginning can be made because we are also learning, your lordships, so despite the advanced, we were still submitting.
Your Lordships, the notes that learned AG and SG has will submit your Lordships will give us till Friday to put it to the.
What? We
The
couldn't
notes,
gather.
your Lordships, because now there's a flood of material which is coming.
Okay, very well.
By Friday, we'll submit our notes.
Now,
What
please,
is
no more.
submitted your notes?
No more.
Because your Lordships, there's a new. flood
That's
of
all right, that's
information
all
which
right,
has
but
come.
it's okay. You are appearing for certain interveners now. To what extent do we keep on
No, your
entertaining?
Lordships, the learned AG and learned SG also.
Maybe so.
Yes, your Lordship. So we'll submit it by Friday as well.
Please don't do that. Please don't do that.
Lordships, because.
We don't want to be confronted with new points.
There
Let's be
won't
very
be
clear.
new
So
points.
we are sealing everything now, except where it specifically permitted.
It's only
That's
for,
all. No,
yes,
I don't-
it's only for Lordship's assistance if Lordship wants it in
please
a
let it be
proper
so.
fashion.
That's unfair because if you come up
We
with
have
some
given you
points, the
sufficient
buttons
time
are-
to make your
There's
own.
no I'm just submitting, there'll be no new information. We are going to
But
just put
then
it in a
if it
manner.
is not in you, please leave it to us. We will
Very
take
well,
care.
as a Lordship desires.
Grateful.
Thank you. We'll come back in 5 minutes, sir.
Right, ma'am.
of the 68 order, total exclusive jurisdiction of the Election Commission of India. So kindly see 15, my lord, which I just complete and then go straight to the 10th schedule. The commission may, after taking into account all the available facts and the circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, kindly mark the next word, my lord. Decide. So for the purposes of 21A, political party, there is a question mark, the decision has to come from here, not from the office holder. Decide.
The issue is not so much whether the election commission has the power or not. What they argue is the batting order, which should be decided first. But the question is, would that arise in a context where the channels are completely different and the process and the method and authorities are all different? But are there any cases where the issue relating to anti-defection as well as matters relating to party determination have been commonly taken up, not episodically, but at the same time?
Lord, I'll just check up, I'll confirm it, but I'll come back to your lordship. My lord, please permit, I have understood, my lord, I'll see. My lord, I'm coming to your lordships are putting it. I'm sorry.
Yes.
Lord, your lordships are putting it to me that in which order these two issues to be decided, because let us assume that the two issues does arise, that who is the leader of the party and whether that incident of disqualification has taken place or not. If these two issues are to be decided, it must be decided first. That's what your lordship are wanting to know. My lord, my respectful submission is this. I will go to straight away to 1A and to 1B of the 10th schedule in a moment. My lord, what I was reading here is the decision who is the political party, who is the leadership, who has to give direction on behalf of the party, in the name of the party. That decision can only come from 15. Okay. Now I'm not only see the 10 schedule, but before that, kindly come to page 8 and page 10 of this compilation one. Because if this is the position, my lord, taken on oath before this honorable court, where the writ petitions are filed on daily basis on every event taking place, after this position is taken up by the other side before this honorable court, ground D, my lord, I want to read only 4 lines and ground next page, page 10, para 36. Then, my lord, therefore, a contradictory position by filing a writ petition would not have been agitated, and that is the reason why no writ petition for the election commission jurisdiction or election commission proceeding is not filed.
Ground D where?
Ground D at page 8.
And this is ground
D. That pages are at the bottom. On the top there is some page 38, but the running page of this compilation is page 8 and page 10.
This ground D, Mr. Maninder saying, this ground
isn't the writ petition.
Part of the writ petition.
Writ petition filed by them.
There
No, my lord, your lordship must know, my lord, that on every event taking place after the floor test, they were filing writ petition. They have taken this position in this writ petition where there is no question on jurisdiction or proceeding further of the election commission. And they have taken this position. Kindly permit me, the last 5 lines in para D. Who is the Shiv Sena? Who is the Shiv Sena? The moment this question comes, my lord, it is also our common case. Exclusive jurisdiction is of the Election Commission of India. And they said so. And once they said so, my lord, there was no occasion for them to file any substantive writ petition questioning that position, because they can't live with the inherent contradiction in their stand. Now, my lord, if that is the position, will your lordship permit an interim application to be filed in some other writ petition? Kindly see who is the Shiv Sena. That is the domain of Election Commission. Admittedly, recognition of Shiv Sena and leadership by so and so has been endorsed by the Election Commission, and there is no dispute. Now, kindly see para 36, page 10, next page. This is a part of the rejoinder, para 36. After our stand was filed to this writ petition, they filed a rejoinder. So original position is, the moment question arises, who should say na? Election Commission. Kindly see 36, third line. If the delinquents were so keen on a change in party leadership, they ought to have approached the election commission in the first place. So what did I came for? I came for extension of time, which is in violation of the rule only 2 days, and I asked for 2 weeks. 2 weeks is granted by your lordship. Compliance of natural justice. That has nothing to do with either the office of the Speaker or the Election Commission of India.
All right, Mr. Maninder. Yes.
Only 2 minutes. Kindly come to 2. Kindly come to 2, but the 10 schedule. 10 schedule. Only about 2 minutes and I am done. All judgments are cited. I have nothing for this hearing. But kindly come to 2-1. There is no political.
Mr. Maninder saying it is read and re-read and re-read.
Only 1 minute I will take. You are not.
Otherwise, we will have to hear Mr.
I will just clear it in 1 minute. 2-1A. 2-1A and 2-1B. The last word of political party and in the contrast in clause 3.2 which is deleted and clause 4.2 of the merger and the split, it's legislative party. Now in this, who is the political party and who can issue validly in law direction to the political party? Unless that question gets decided, there is no ambiguity in that regard. Speaker has no jurisdiction. And that is why the order is that once such question arises, EC will decide first. And that is their writ petition. Ground D and para 36 in rejoinder. Grateful, my lord, I am deeply obliged.
Thank you. Yes, we did, Nani.
Very brief. My lord, I realize the lordships are very keen to hear a detached voice rather than partisan interest. Lord. So I'll just state my proposition. Lord, my learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. Now, Lord, the question of disqualification, and what incidentally I hope to answer my Lord Narasimha's query. The question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. Although there is no concept of potential or deemed disqualification, it has to be actual, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the Deputy Speaker, in this case, there was no Speaker because the then Speaker had resigned since 5th February 2021. But the Deputy Speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House for his position as Deputy Speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as Deputy Speaker, i.e. the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it. But it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the Speaker of the Deputy Speakers, a majority is itself questioned, he must desist from the adjudication process. Now, it's not just Navam Varia, which is one of the questions of law propounded. Navam Varia does say so. And we're having a second look at it, but also Article 181. Then we got two more propositions.
Yes.
Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner is determinative of this matter. That's almost conclusive. But any possible link between disqualification and the power to the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned, 29th July, June. 29th June. I'm so sorry, 29th June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the Chief Minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the House, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us lots of the citation. Rameshwar Prasad. In that judgment, the court said, when the governor is setting about the task, and it's paragraph 161 in particular, what you just know, when he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Rameshwar Prasad.
Yes. 2006 to SEC page 1. The Legislative Assembly of a state shall, as soon as they be, choose two members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification, and my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord, I will play.
Thank you.
Mr. Datar. Well, just one question of Justice. Well, there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10th schedule and the election commission. It's a division bench of the Kerala High Court.
What is the citation?
Yes. Okay. It's in the compilation. It's 2021, 4 KLT SN 33, page 51. But it's an I compilation and it's judgment number 7 in our compilation of it. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned, and the impact of each.
Mr. Solicitor, you want?
Sir, only 5 minutes because I appear for the governor. Therefore, my role is different. In my role, I have already played, and if required, I may play. But only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background, and 5 minutes is broadly outer. When 324 was framed, so there is a beautiful discussion which I will not read, I will pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of president rule, etc., in a different fact situation which is not arising. The only question, my lord, which needs answer for the today's limited hearing is, can your lordships take a call whether this faction is right or another faction is right? That answer, my lord, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, two factions claim that I am the original party. Somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Kaul and Maninder Singh, would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party. Would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordships are assisted on both spheres. Yes. Here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech and expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party because there is no disqualification from membership. So the Election Commission is merely deciding which group represents the original party. So, right now, for the limited purpose, my respectful submission is that let the Election Commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta.
My submission is earlier that the functioning of the Election Commission is completely different and independent from the role of the Speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. We'll have to first go to those articles. Lordship just takes 10th schedule. This Articles 102.2 and 191.2.
Yes.
And Lord, since we are referring to a state assembly, I will confine myself to Article 191. So, Lord, I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note, along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 102.2 and 191.2. And if your Lordship sees 191.2, a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Now, please come to 191.1a. the Lordship kindly sees, person shall be disqualified from being chosen and for being a member. So, my lord, there are two types of disqualifications. A threshold disqualification, where you can't even become a member.
And during the
Second, during. But in the company law, they use more elegantly. They say disqualification and vacation. You become a director, then you vacate the office. So when we say disqualification for being, it actually means disqualification from continuing as a member of the house. Now, Lordship will just see A, if he holds any office of profit, B, if he's of unsound mind, C, if he's an undischarged insolvent, and D, if he's not a citizen of India and has voluntarily acquired citizenships, etc. And E, if he's so disqualified under any law by or any law made by Parliament. The Lordship will find that there are 4 constitutional disqualifications, which is A, B, C, D. The 5th constitutional disqualification is 191(2). And if your Lordship sees what is 191(1)(e), if he is so disqualified or under any law made by Parliament, Lordship has to look at the Representation of People Act 1951. But I will be basically referring to the Constitution and the Representation of People Act, so Lordship will just keep these bare accents. Great. Now, if Lordship just sees the index, the table of contents of the Act, of the Representation of People Act 1951. My Lord will find that as far as the Representation of People Act is concerned, please see the table of contents, the index will give you also the architecture of the Act. Chapter 1 and 2 talk of qualifications. And my Lord will kindly notice that chapter 3 and 4 deal with disqualification. Yeah, it's a very small act.
I just, in an order yesterday, we said 50. I just told him I had a recollection that I did.
Yes.
50.
In fact, the statement of office and reasons say that 50 Act is very short, so we have to expand it further.
Yes.
So, Lordship will kindly come to chapter 3, just the headings. Definition, disqualification for conviction, disqualification ground of corrupt practices, disqualification, etc., etc. And chapter 4 is disqualification from voting, where you are a member but you can't vote. Now, what I'm submitting is,
yes,
the Parliament and the Constitution has consistently made the difference between what are disqualifications under the Constitution and what are disqualifications. As far as the Representative People Act is concerned, the authority to decide is the Election Commission. Actually, I'll come to 191. The President will decide, but he will take the opinion of the Election Commission. If your Lordship now, so the point I'm making is, the disqualification given in the Representation of People Act 1951 is a completely different thing. The role of the Election Commission, being a constitutional body, is clearly demarcated, and it is neither hedged nor restricted by the 10th schedule in any manner. If your Lordship now comes back to 191, the next section 192, Article 192.
Yes.
If any question arises, 192. And Lord, this is equal to 103. Lord, just makes a note. Parallel provision Parliament is 113. If any question arises as to whether a member of a house of a legislature of a state has become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the governor and his decision shall be final. 2. If before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. So, disqualifications in clause 1, there are constitutional disqualifications plus under the Act. These are decided by the governor, but he will take the opinion of the Election Commission. Now, Yeah, and Lordship will kindly note the governor shall obtain the opinion of the election commission. So he has to. So the Act very clearly demarcates the role of the election commission as quite distinct, separate, and the parameters are prescribed. Now let's go to the 10th schedule. Lordship will first see para 2C is original political party. Original political party. But if my Lord sees the definition in the Representation of People Act 2F, my learned friend, I think somebody referred to the rule, but if your Lordship goes to the Act itself, the Representation of People Act under 2F, political party. Political party means a political party which is, once again, this opens into the 50 Act.
Mr. Maninder Singh referred to that.
Okay. He referred to the rule.
Identical.
Identical.
Simple order.
Yes, I think in the simple order it's 2H and here it is 2F. But the point I'm making is the purpose
2H.
Yeah, 2H in the rules, 2F in the
2F corresponds to 2H.
Now, it talks of political party means an association or body of individual citizens of India registered with the Election Commission as a political party under section 29 capital A. And just see 29 capital A for a minute. Registration with the Election Commission of associations and bodies as political parties. So Lordship will see, it's not necessary to have to be a society or a trust. It can just be what we call an income tax, an AOP, or a body of individuals. The association of body of individual citizens, calling itself a political party and intending to avail itself of the provisions of this part, shall make an application to the Election Commission for its registration as a political party. Now, my Lord, my humble submission is the need to call, when you talk of original political party, that means there is something which is original and something which has come later. That must be because of the provisions of para 3, where a group of people could split and form a separate party. So that could perhaps be the reason why they use the word original political party, which means the political party contemplated and registered under section 29A. That could be the original political party. And para 3, where they say that if more than 1/3 people split, they could sit as a separate member. And in fact, the 91st Amendment says that this bulk defection is causing harm, and therefore they decided to do away with para 3 completely. So my submission is original political party must be understood to be, in my humble opinion, the 2F read with 29A party. That is the party which is registered with the for the purpose of anti-defection. They said that even if more than 1/3 members go, it will not amount to defection. That has been done away with. So now basically original political party will now be relevant only in the context of merger, which I will come to later. But for the purpose of us, that's the meaning of original political party. Now what is legislature party? Legislature party means, Lordship sees the constitution. Legislature party in relation to member of a house belonging to any political party in accordance with provisions of paragraph 2 or paragraph 4 means the group consisting of all the members of that house for the time being belonging to that political party in accordance with provisions. Therefore, if the political party is a larger set, then the legislature party is a subset of members of that political party who are also being elected and now form part of the house. It is quite possible that you can have a political party with no legislature party. It's not that every political party has MLAs and MPs. So, legislature party is a subset of the original party. That is, every legislature member, every member of the legislature party will necessarily be a member of the political party. This is the. Now, Coming to the role, now what is the question here? As Malad just put it, the batting order. Suppose there is a case of a split in the house in this particular case. But I am arguing a case independent of any kind of, as a general principle of law, what is the role of election commission? Suppose there is a defection crisis in any assembly or parliament and the matter is sub judice either before the High Court or the Supreme Court. Does it stymie? Does it stop? Does it interdict the functioning of the election commission? Is a question which a lordship has to answer. And my humble submission is, when do we avoid parallel proceedings? We generally avoid parallel proceedings
when the jurisdiction is concurrent.
When the jurisdiction is concurrent, and typically there is a higher forum and a lower forum. And as a general rule, the subordinate forum will yield to the higher forum. So if a matter is pending in the High Court, say for example in a tax matter, and lordship gives a notice, then typically the officer will not proceed because he will await the decision of the High Court. So parallel proceedings come where the jurisdiction is concurrent, and there is a possibility of the possibility of two authorities coming to contradictory conclusions. The second point I would request the lordship to kindly consider, 10th schedule is legislature or member specific. Regulation 15, para 15 of the symbol order is party specific.
So the issue of disqualification would really relate to the membership of that house.
Of that house, that's what why
a particular state legislature, or if the case may be one parliament.
191(2) says you will be disqualified member of that house. It doesn't say anything about the political affiliation, political party membership.
Para 15 is really agnostic on the legislature because that is irrespective of whether there is or there is not any disqualification.
In fact, as I mentioned, that political party may not have any member of a particular house also, or it may have members. So what we are concerned is, now if your lordship sees the what I call the structure of a 10th schedule, first one is definition, 2 is the substantive, what is disqualification, 3 and 4 are exemptions to that disqualification, that is 1/3 member and merger. So 2 is the bar, the disqualification, 3 and 4 are exceptions, 5 is also an exception where it says that if you are a speaker, it's very unique for a speaker, if he gives up his membership, then when he comes back, he will get disqualified. 6 is the procedure, which came up for consideration in Kyoto Hall, and 7 are the rules. So if a lordship kindly says every para in the 10th schedule refers to the disqualification of a particular member. The lordship, para 2A, for example. Here is a case where 2A of the 10th schedule. I'm trying to say, Manoj, that the fields are completely different. The territory is completely different, so to speak. Ballot kindly comes to 2(1)(a). A person who has voluntarily given up his membership. Now, Manoj, it is absolutely common sense that if a person is given up his sense, he's now going to file an application in clause 15 of the symbols order. People who come for the symbols order are saying, look, we are in this party, the rival group is in this party. Please decide who's the real party. So 2(1)(a) will never apply. What is 2(1)(b)? You violate the whip. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Datar, is that the issue of giving up the membership of a political party within the meaning of 2(1)(a) is not confined to your activities within the house.
Yes. In my submission, Lord, I would submit that will partly depend on, because what I'm submitting is, if a
because voluntarily giving up the membership of a political party is not confined to what you do within the folds of the house. Unlike 2(1)(b), which is votes or abstains from voting in the house.
Yes.
But 2(1)(a) is much broader. voluntarily gives up membership of a political party.
No, I'm sorry. I absolutely no.
And therefore, the speaker's power to determine that is not therefore confined to what takes place within the fold of the house.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, a particular member of party X has attended all the meetings of party Y. He has participated in the functions of party Y. Then has he given up his party or not? So in some cases they say, yes, it's amounts to giving up membership. But that's really outside the scope of this reference. That's why I did. So when you say voluntary, Lordship is right. That's why under clause 6, the speaker is called upon to say that Mr. X, he attended the rallies of this party. But the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no, but his name is still continuing in the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it a, I mean, it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is.
But one thing is very clear that, 2(1)A as well as 2(1)B is member specific.
Yeah, member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents a political
party. Now, Lordship will come. Yes. So, Manoj, what I'm submitting is, paragraph 15 basically refers to the collective right, the collective party. Who is the real party? And if your Lordship now comes to paragraph 15, which your Lordship saw a number of times, I will go through it again. And if your Lordship has seen Sadiq Ali several times, I won't repeat it. But the first 2 paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa linked with the Congress O, and Jagjeevan Ram was Congress A, but we've all gone through that controversy in those days, the Congress O, the Congress, etc. And then the argument was that the Congress O had majority in the Congress Working Committee. Lordship, can you just assist your broad outline of that case?
Sadiq Ali is of which year actually?
1975.
75.
But this took place in
1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because Justice Khanna remarks in an abnormally prolix order. The prolix itself is abnormal, but his Lordship says abnormally prolix order of 437 pages. The Election Commission has drawn. There, what happened was, Lordship will just keep on just 2 points. Lordship will know. Sadiq Ali deals with 72 Supreme. Sorry. It's Sadiq Ali says 72-4 SEC 662. Sadiq Ali says the Election Commission went by 2 tests and that Supreme Court approved. One was the test of majority. Test of majority way Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjeevan Ram faction. Y are in the Nijalingappa faction. They go statewide. But you want to see that, I can show that later. That's the way. Then they say, at the All India Congress Committee, Working Committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by test of majority in this. The point is not what we are doing. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they're doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NRDMK. Hearings took place, matter came right up to the Supreme Court. And what the Election Commission they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiry. Now, please see my notice under paragraph 15. I am humbly submitting that this notice has nothing to do with the tension. Chapter 15. Lordship will kindly see out. Yeah, please see the page. Please see my notice. No. The notice section 15 notice. 44, page 44. Yeah. Lordship will see paragraph 40, page 44 of R4's compilation, volume 1. 22nd July 22.
Documents.
Yes, yes. Document number 9. My lord is gone.
Document number 9.
What is it? What
It's
is
in the
it?
Sadiq Ali compilation.
No, no, no. It is the compilation of respondent number 4. Volume 1, respondent number 4, compilation of documents and rules. And this is document number 9.
Notice
Yes.
22nd.
22nd, your my lord is right. 22/7/2022.
Page number?
Page 44. So the pages are coming at the bottom.
Yeah. We have got total 118 page.
Yes. So Lordship will kindly see the notice is sent to both and then subject so and so. After the preamble, kindly come to para 2. The commission is in receipt of communications as delineated below. She is so and so member of parliament and secretary of party on 25/6/2022 intimated the commission about the alleged anti-party activities carried out by some of the MLAs under the leadership of so and so, and objected to establishing any political party using the name Shiv Sena or Bala Sahib. Anil so and so forwarded 3 letters dated so and so. And so he gives a comment. Then Sri Anil so further email it an affidavit of so and so. Now kindly come to E. Sri Eknath Shinde on 19/7/22 filed a petition before the commission titled as so and so on the para 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, I mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to para 3 at page 47. Now this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para 3. Para 15 of the election symbols and reservation allotment order 1960 provide that when the commission is satisfied on information, your lordship see para 15, I won't read it again. On due consideration of the totality of information available on record with the commission as summarized above, the commission of this of opinion that there are 2 rival groups in Shiv Sena party, one led by Uddhavji Balasaheb Thackeray and the other led by Eknath Rao Sambhaji Shinde. Each group is now claiming to be the party and therefore the matter requires a substantive determination by the commission under para 15 of the election symbols. In order to place both the rival groups on even keel and to protect their rights and interests and going by the past precedents, the commission has directed the documents submitted by the rival group be exchanged and the reply written submissions be invited from the 2 groups. The steps envisaged under para 15 proceedings prior to the hearing rival groups they require both rival groups to submit the respective documentary evidence of the support claimed by them, the organizational and legislative wings of the parties. Accordingly, Commission has directed both the group to furnish written submissions and their respective documents to support their claims by 8th August 2020. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on in the matter. But then the court said, please furnish documents you asked for. Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Nothing. Secondly, my lord, by submitting this application by respective sites, none of the provisions of 10th schedule are attracted. Because 10th schedule disqualification is limited to 2(1)A, 2(1)B. So my submission is, as somebody mentioned, para 15 is like the inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. I think that Anna DM.
I don't think we need to go into the issue.
No, what I'm saying is because Lordship will see number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
So, Data, you have already said so in your paragraph 3, the procedure to be followed by the election commission. You have already stated so.
Thank you, Mr. Datta. So my humble submission is not only in this case, but as a general rule, my humble submission is whatever happens on the floor of any particular house of parliament, that will be completely independent. It will not impact the function of the election commission in any case at all. Two things can happen. Either Lordship may allow the petition or dismiss the petition. The result of the para 15 order will be complete party, but not nothing political.
Yes.
Keep clear.
Thank you.
Thank you, Mr. Datta. Yes, Mr.
My judgment is right. These two 10 schedule and para 15 operate in different silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up members of the party doesn't happen in the house. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the house. All this is outside the house. And the speaker will have to consider, for the purposes of coming to the conclusion, whether you are voluntarily giving up membership of the party, not the house. It is because of that you are disqualified in the house. Giving up membership of the party outside the house amounts to disqualification within the house. So you can't say one is different from the other. What happens in the house is unrelated to what happens outside the house. And the election commission can't say, I'm not concerned with any of that. Number two, Manoj, in paragraph 21B, if you vote against the whip, you will be disqualified not just under 21B, but also under 21A. Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh Rani. Let me just give you a notice briefly what it was. Of the BSP. Joint hands with the Samajwadi. Now, there were 109 members of the House. The Speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the Speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the Speaker. They were at that time not 1/3. The Speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 13 members approached Speaker. That's one part of it. My argument is completely wrong. That is unrelated to the issue of giving up membership of the House. When paragraph 3 was, before it was deleted, very interesting.
it is integrally linked with the political party. And we see our compilation of statutes. Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. Sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes.
Yeah,
This footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it out.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction. And you see whether the correlation of this with paragraph 15, which has arisen as a result of a split in the original political party. It's 115 of their compilation. Have a look at that. Better others we did.
You can.
And such group consists of not less than 1/3 of the members of such legislature party. He shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the speaker decides in the paragraph 3, Rajendra Singh Rana says, merely because you make a claim is not enough. The speaker will have to prima facie decide that there has been a split in the original political party. So it's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just read 37 because that's why I wasted time there. This is 1074 SCC model I have. In their compilation is 192. Para 37. I am reading 36 and 37. 192 models probably. So 219, my lords. Verse 219, they are quoting Jagjeet Singh Miller's paragraph 69. The lords, my lord, just that's in italics, not in italics, but in indented. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that the claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the state in the original political party, cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part, having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the Speaker of the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the Speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Para 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to him. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. Now, if it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. But what will happen on the 19th of July thereafter has nothing to do with what's happened before. Because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. Well, let's see our Volume 2. First, we show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Sindhya on the 30th of June. This is much before 19 July. At page 321. Convenience compilation, volume 2, page 321.
Yes.
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by your acts given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. Even now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Malas, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, Manas, how is that possible to say that no, these are two different silos? Now, Manas, and therefore, Manas, I am saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Manas, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where a original political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Manas, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. So he merges with another party, or he has another party merge with him and he forms a new party. the new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off from himself. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's found a new political party. And those who are left behind, that is, who are less than one third, because 2/3 makes others, those belong to the original political. In this case, Malad us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that over the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Sibal, you can conclude your argument.
No, you are rejoined the council.
They have argued for this.
No, that cannot be tit for. No, that cannot be tit for tat that he has taken 2 hours.
Cited certain judgments for which
All right, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction, what we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it. Now, therefore, now let's come to paragraph D.
Paragraph D of
okay. Our Mr. my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
Ah, yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that Kerala judgment, there are 2 other judgments. It's all right. Read the whole paragraph.
No,
Let's read the whole paragraph.
Ground D of ground page 8, right?
Because and children. That's the point, Manoj.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, Manoj. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other.
I'm
not saying, I'm only saying, Miller, he says these are great repercussions. Because in this situation, then X number of people of a political party who are in power can be named away. Governor will give them votes and will go to the election commission and say, you declare us the simple murders. And that's the consequence, which is sought to be prevented by taking away the third paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is let's not have these splits. Then paragraph 36 minutes. Also read it half of it. I'll just read that minutes. Page 10 minutes. On the contents of paragraph 24 to 32 are denied. it is submitted that clearly claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of a Whip 3.7 as well as a 4.7, and having read the writing on the wall as to their imminent disqualification from membership of the Assembly, the splinter group has now rushed to the Election Commission to claim that they are the real Shiksha. Well, this is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. Then, my learned friend cited two other judgments. Whereas Kerala judgment where there was no disqualification.
2021 4K 3 he said at page 50.
Well, then,
but he didn't read it out.
Let's see Palani whether he cited. Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Rani Swami had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment my learned friend cited is the Kerala judgment. So by that my colleague.
That Mr.
Jetmalani cited.
He didn't cite.
Para 4,
He really just gave us a citation. He has no doubt.
No, he said that this is the first time the court has decided.
Page 51.
Yes, now I just note para 6 of that judgment says, the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 minutes. Para 6.
At page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiyalal Umar. Now, Kanhaiyalal Umar, brothers, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. Then there is all party Hills Leaders Conference, brothers. That was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let's kindly see what the notice of the commission is to us. Page 701. Compilation of this document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
Got it. That is document number 9.
Yeah, on due consideration of the totality of information available on record to the commission, as summarized above, the commission is of the opinion that there are two rival groups in Shiv Sena party. So he's already assumed that there are rival groups in Shiv Sena, when the whole question is whether he's a part of Shiv Sena or not. One led by Uddhav Thackeray and the other led by Eknath Shinde. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my thing. I am saying he's no longer in the party, he's voluntarily given up. How does he, on what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, but this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas he can't, the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He has voluntarily given up. So on what basis does he say on even keel? And to protect their rights and interests and going by the past precedent, commission has directed that the documents submitted by the rival group be exchanged and replied. Even then, then was interesting. The steps envisaged under paragraph 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. And they are aware of my letter, at paragraph 2, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, commission can't decide that issue. So now let's go back to the last part at 702 that I was reading. Support claimed by them in organizational and legislative ways. Let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment says that has to be considered. So if the legislative wing, according to us, all 40 of them, are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shiv Sena when they are voluntarily resigned. I have informed you about it. And you say we will treat it as an even keel. Now, nobody disputes whether a big argument is made about 324. Nobody disputes that power. Who disputes the plenary power of the Election Commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the Election Commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first will be given priority in terms of decision making. If it is an afterthought that after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the Election Commission on the 19th of July and say, I am the party mother. Certainly the Election Commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of election. And what used to happen, the history of litigation in this area would have shown that every faction used to throw out membership, members of the other faction. And obviously, Election Commission could not decide those issues. So they say, okay, let both factions come and we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we have 2-1 at all? It is only a question of the legislature. Argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the Election Commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Can't turn the clock back. Election Commission has decided. So it makes my petition infectious. If our lordship decide against me and say, no, what happened was perfectly legal, in any case, they will get the symbol. So they are not in any case prejudiced. Why is it that we want this to go on today? When your lordships can decide this matter in October, here the matter decided. What is the great urgency today that this must go before the Election Commission so that the other freezes the symbol or gives it to somebody without having this matter decided? And then they say, look, my speaker is there, my speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. They must have glossed over. So how will the speaker decide that issue? And then the larger question is whether when you go to the deputy speaker, that you are disqualified because we have moved a notice of removal against you, Mother. The speaker said this hasn't come from any source at all. It has come from an email that I'm not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And Mother, what's interesting is this court, I'm sorry, Mother, I'm taking time and I didn't want to take too much time when you watch it. But let's see what the order of the court is on the 27th. Then show me careful. Well, it says, meanwhile, as in intent, sorry, Yeah.
What is the date of the ordinance?
Date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and treating is there in page C, Manas.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On page
Meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Millet? Now see to Holo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended it. Now let's see the order. See Kyoto. Para 110. Order is in the teeth of 5 the constitutional bench of this court. Then the government was talking. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I read it. No need for curiosity. In view of the limited scope of judicial review, it is available in para 6. And also having regard to the constitutional intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interact the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, we said, in fact, I remember I told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It has no difference. It makes no difference. Inner party democracy is in the context you all continue to be a member of the party, not with anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it. And this is inner party democracy that's been given up. So this concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide whether in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. That's
Thank you, Mr. Yes, Mr. Yes, Dr. Samir.
I'll give it in point form. What is the crux of the case? Or the nature of the phrase voluntarily giving up membership of the party. Whereas in actual practice, 90 if not 95% of acts or omissions coming under 21A relate to activities outside the house by the very nature. 3 examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust vote, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to take only 5 minutes. Ravi Nayak. Before I cited the book, out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordships, kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The infer, word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read first that middle practice. Middle of para 11, my lord. The said paragraph provides for disqualification of a member, they are talking of 2 of a house belonging to a political party, if he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party, even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordships, fellas, has to consider, and not your lordship, fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. An inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And that is what is happening. Point number 2 is, your lordship may kindly read again to save time, I will not read it, the 4th of August 22 order of this honorable court. The last 4 lines, we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Tata, it says so. The proceedings may take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is whether the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This is point number 4. This ground of IA. your lordship, because I don't think should be catered by the form of an IA versus the substance of what we are. That's the simpler answer. But two more important answers for us in law. It would be, according to me, quite quaint if your lordship said that because it's an IA, your lordship can't decide this matter, it's outside the scope of the main matter. But there is two other answers, factually wrong. Number one, we find several writs, including what your lordship may call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this Election Commission is initiated. I have filed an IA saying that this is a subsequent development. Why your lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your lordship cannot touch it? Therefore, that is, well, I hope, not their best answer. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Paul read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Paul read the sentence to be very
That's para 27 and 48. There's just one more. Let me
Mr.
go to grammar.
27 is the answer to 25, which was read. The context is placed in 27, which was has to be read.
Just give us, just give a moment. Page 192, right?
Yes. So my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para classical C. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim, mark word independent, of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Paul read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the Speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the Speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal while considering a claim for disqualification of a member or members to decide that, but also in the context of the 3 raised by this that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the Speaker, who is a persona designata by the Constitution, no less. Now, while your worship is on this, just let me finish on 48 of the same judgment. Also, not great. This is just 2 lines. This is just to connect, but that's one out of hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involves a very specific case. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership to the party or to speak it to said members and party. It is because all over the press and repeated that they met in this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in Paramatma. My fifth point is that your lordship is cited. I want to make a general fifth point and then tell your lordship. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded my submission. It's a rather broad thing, I don't want to make a wrong statement. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is Omar, etc. 1985, 4 SCC 628. Just note the citation I not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules? That's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also, I'm not saying, but I'm saying that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be peripherally decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes speaker is disqualified. Then the persona designata, then you start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps will interview. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 2.1a, which the speaker to his designee decides. Today, in fact, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided to this?
Decided first is what your lordship is told. I will let the EC decide it first. B, is the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will be decided by the state.
That's just one submission for your lordship's kind consideration. Only on Kyoto Holo.
No, it cannot be, Mr. Then there should be a
Kyoto Holo. Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. Kyoto Holo said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and when the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibbal presumes that we are disqualified and the EC today cannot be approached.
All right, first issue. Yes. We have heard Mr. Kapil Sibal
and Dr. Abhishek Singhi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Mr. Tushar Mehta, then Solicitor General, has appeared on behalf of the Governor. Mr. Arun Detta, then Senior Counsel, has appeared on behalf of the Election Commission. Next. Having heard the. Sorry? Oh, yes, Mr. J.
What's it forgot me?
I'm so sorry.
No. Quite forget.
No, not at all.
Apologies. Having heard the Learned Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
It is allowed.